She could not appear before. He could not appear before the honorable court.
Heard Mr. What is your name?
Be secure.
Heard Mr. B. Soikia, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel, Mr.
As new.
S. Neog, is indisposed. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
A similar prayer for item number 11.
This one,
11.
10 and 11. Same ground, same order.
Much good. For anticipated page matter, FR is page 8 matter. That cause of action arose on January 2024. FIR lost in the month of 2nd October 2010 matter after 9 months. The petition for villagers matter. He has no knowledge regarding this matter. Only for harassment matter, and this instant FIR by instigation of the other side of the court. Only to harassment. So, matter kindly protect him and call.
Yes, Mr. Bhattakur.
Thereafter, CB is now pregnant of 9 months. Okay, thereafter, my city laws, FIR laws,
But there is a delay of 9 months.
this type of offenses, my lord,
9-month delay is a long delay.
50 days.
After
Let him hear. Heard Mr. B. Islam, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioner Mohammed Sultan Ali alias Mohammed Sultan Ahmad, who is apprehending his arrest in connection with my own PS case number 109/2024 under section 376/493/506/34 of the Indian Penal Code. The gist of accusation in this case is that on 2/10/2024, the victim herself lodged an FIR, inter alia, alleging that on 26 January 2024, the petitioner gave Rs 100 to the victim and instigate and assured her that he would marry her and thereafter indulge in physical intercourse with her, as a result of which the victim became pregnant and she is now carrying pregnancy of 9 months. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR are not true and the petitioner is innocent. He also submits that the falsity of the allegations would be apparent due to the fact that there is a delay of about 9 months in lodging the FIR. However, no explanation is given in the FIR justifying the delay in lodging of the FIR. Stop. On the other hand, learned additional public prosecutor submits that considering the nature of offense involved in this case, perusal of the case diary would be necessary. So, let the case diary be called for. However, considering the fact that there is a long delay of 9 months in lodging the FIR, the petitioner, the above named petitioner is directed to appear before the investigating officer of Mayan Police Station, case number 109/2024, within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. Let this case be listed again on 6th of January. 6th of January.
Your lordship. Since it declared under section 482 of the various annexure 2 page 12 is the FIR line.
What is 305?
305 is theft in a dwelling house.
Dwelling house, and 331
I got it is looking house trespass. Trespass and subsequent 5 is minor joint criminal liability for intent.
what are the allegations?
My lord, the application here, my lord, annexure to page 12 may be permitted to read.
Yes.
My respectful submission is that today at around 3:30 AM, when 4 cows from my cow shed were silently tried to be stolen by 5 persons. At that time, my brother Amol Proza saw and made hue and cry. Though they went away with the cows, but the villagers were able to get hold of 2 persons. Since in our Biju locality, since several days such type of cow stealing was going on, as such, the local public out of anger assaulted them, and in that agitated situation, my brother got injured. By considering the situation, we handed the two thieves brought by us and the Bolero pickup vehicle brought by them before the police outpost. After interrogation, we came to know that the name of the two arrested thieves were Imdaz Ali and the name of the other accused is Raza Khalid. And as per knowledge, the name of the other two persons are Nabi Hussain, Majdul Ali, and Kodam Ali respectively. Presently,
What is your name?
my lord, my name is Nabi Hussain. I am the owner of the vehicle. I am the registered owner of the vehicle. And if we look by the FIR also, my lord, for a second, if we look by the FIR also, my lord, at 3:30 AM, 1 person saw that 5 persons were going inside the cow shed and they were trying to steal 4 cows. And they made hue and cry and all get up. Within that period, they fled out. They said that they were able to get the cows in the van, and if we go by the FIR in its contents also, well, it doesn't sound to be the genuine. And moreover,
It does not.
4 cows, can it be put up in a Bolero pickup within a second? See, they saw, they made when everyone was pick up and they went. And if we look by the contents also. And moreover, my lord, I am not on the contents, but my submission is that I am Nabi Hussain. I am the registered owner of the vehicle, and I have given my vehicle to the driver of the vehicle, and the driver, I have stated categorically in my paragraph.
Vehicle was seized.
My lord, vehicle was seized, and the cows were also immediately, my lord, everything was reported.
Stolen cow were found on the vehicle, in the
Yes,
vehicle.
they have not stated exactly that part, but they have not, as per the first part of the FIR, it states that in that way. But if we go by the FIR,
You were one of those 5.
according to them, my lord. My lord, may kindly see the FIR. My lord, for a second, they stated that at 3:30 AM, 5 persons silently went inside the cow shed. At that moment, his own brother saw and made hue and cry. Then thereafter, 2 persons were caught hold along with the cows in the Bolero pickup van. So if we go by the FIR, may not be those,
What has happened to these two, Rajak and Imtiaz?
they were arrested.
They are still in custody.
Custody, and they were, my lord, actually they were the persons who had done the offense. They were immediately, my lord, got told by the public.
Yes, Mr. Borthakur.
I am the owner, my lord.
On the one hand, she is talking about the other 2 persons are main accused, and on the other hand, my lord, he stated that the entire offense is not genuine. My lord. In a Bolero pickup van, my lord, how that, my lord, 4 numbers of my lord, Ketal sir, in a wagoner vehicle, my lord, by
My lord,
lifting the rear seat, my lord.
It was.
this
Okay,
kind of
okay.
consider-
Case diary.
It's not found in
Case,
the vehicle.
we'll fix a short date.
My submission is that it was not found in the vehicle. They were about to commit the offense.
Okay, no, let us verify.
I am the vehicle owner and I have categorically stated, I have given on Razak Ali with a monthly, with a daily rent of, I get daily rent of rupees 800, para 5, page 4. I have categorically stated, para 5. I have given my vehicle to him. And I get a rent of 800 per day, my lord. And the public got hold of the persons, my lord, these two persons.
Which police station? Not.
My lord, it's North Lakhimpur Police Station, my lord. My lord, I am local resident. I am will abide by any condition. I have no such past antecedents also. I have taken this vehicle on loan and I give on 800 per day on rent.
Yes, Mr. Bhattakul.
There are other persons were portrayed here. I thought that my, yeah, but is there any?
My lord, if during vacation is not looking for money. But sir, abide by any condition, any strict everyday appearance will also, my lord.
Heard Ms. S.G. Burwal, learned counsel for the petitioner. Also heard Mr. P. Bhattakul, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Nabi Hussain alias Nabi Hussain Ali, who is apprehending his arrest in connection with North Lakhimpur PS case number 246/2024. The section 3 within bracket 5/305/331 within bracket 4 of BNS 2024. The gist of accusation in this case is that on 19/8/2024, one Sri Bimal Praja had lodged an FIR before the officer in charge of Salini Bari Police Outpost, Inter India, alleging that on that day at around 3:30 a.m., he saw 5 persons trying to steal 4 cows. And at that time, his brother Amal Praja made hue and cry. It is stated in the FIR that the local people who gathered there apprehended 2 persons, 2 thieves, namely Imtiaz Ali and Raja Ali. And during interrogation, the apprehended accused named other 3 persons who are involved in the offense, including the present petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner is not involved in the offense alleged in the FIR. His only involvement is that he happens to be the owner of the vehicle, owner of the Bolero pickup vehicle, which has been seized in connection with this case. She submits that the petitioner used to give his vehicle on rent to whom you have given,
Razak Ali.
and on the date of the incident, the vehicle was taken on rent by one of the apprehended accused, Raja Ali. He also submits that the petitioner is a local resident of North Lakhimpur and he would cooperate in the investigation if allowed to if he is allowed to go on bail. Stop. On the other hand, learned additional public prosecutor submits that the name of the petitioner has been implicated by the apprehended accused persons, and therefore apparently there are materials against the present petitioner on record. He, however, submits that perusal of the case diary would be necessary for considering the instant bail application. Stop. All for the case diary. Fixing 6 January for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as considering the nature of offense involved in this case, the petitioner is directed to appear before the investigating officer of North Lakhimpur PS case number 246/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to this satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this matter be listed again on 6th of January.
Yes, my lord. Thank you.
For three bail application, my lord, FIR is my lord 8, my lord. This is my lord totally, my lord, after making conspiracy, my lord, this FIR has been lost, my lord. I read the FIR, my lord.
Yes.
Respect that we took the TS order on so and so. While I was sleeping after having dinner, the Pida mentioned it is person by taking advantage of absence of my.
Case diary would be required.
My lord, in the meantime, my lord, the informant on an affidavit, my lord. Kindly seek this,
Informant,
my lord.
victim.
Yes, my. Yes, my. That
Otherwise,
is my lord
affidavit,
compromise,
my
my
lord,
lord.
only let CD come.
Already,
And
already
let them,
compromised,
my
my
lord,
lord.
Where is the, where?
Wait. My lord, I have pen it, my lord, page 14, my lord. Already, my lord, settled amicably, my lord. After, my lord, under the guidance of the local.
let the police submit a report, my lord, whether this affidavit has been filed. by
In
the
the meantime, my lord,
No, we'll, considering the nature, we'll call for case diary, fixing a short date. No protection in between.
the meantime, my lord, I will be protected, my lord.
No, police will not arrest you if a victim has compromised.
Let them first submit this affidavit before police.
Yes, my lord, already we have
Verify.
submitted from my lord, village.
Police will verify, my lord, whether this, my lord, affidavit has been filed by the victim or not.
My lord, in the meantime, my lord, I may be protected, my lord, and my
At the
lord,
time of getting the
CP, my lord, reveals that whether this. has been-
No. Because of the nature of offense, not without perusing the case diary. We will fix it. We are fixing a short date. Heard Mr. A. Hussain, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application, in spite of the fact that the petitioner has annexed an affidavit purporting to be sworn by the alleged victim. Victim is not the informant.
Yes.
Alleged victim who has, wherein it is stated that the matter has been amicably settled between the parties. Let this matter be listed. When can you bring the case diary?
70. Page 9.
No, which is the police station?
Gauripur Police Station, Joguri District.
Let us fix a shorter date, 13th.
13th, my lord, Saturday.
13th is Friday.
Fine, fine. Obviously. That is a lot. Similar for it to application, my lord. The FIR page 8. This has been registered C 29 3 1172. These two sections are available, my lord. 74 is unavailable. Page 8 is the FIR, my lord.
What is 74?
74, my lord, use criminal force, my lord, with intention to outrage modesty. That ingredients is corresponding section 354. 354, my lord, earlier. The FIR, my lord, there is nothing about 350.
Yes, Mr. Bhattakur.
Absolutely nothing.
In FIR, there is no allegation of heard Mr. R. Ali, Lanet counsel for the petitioner. This application under section 482 of BNSS 1 2023 has been filed by the petitioner Khalil Ullah, who is apprehending his arrest in connection with dispute case number 1270/2024. Under section 329 within bracket 3/3117 within bracket 2/74 of BNS 2023. The gist of accusation in this case is that the victim has herself lodged an FIR before the in charge of Bhagadatpur Police Outpost, on 28/11/2024, inter alia, alleging that the petitioner had borrowed, that the first informant had borrowed a sum of rupees 1 lakh from the present petitioner and used to repay the same in installment. However, as the informant failed to pay the amount, it is alleged that the petitioner went to the shop of the informant and physically assaulted her, due to which she had sustained injuries. Stop. Learned counsel for the petitioner has submitted that, which is non-bailable,
74.
that though the instant case has been registered under 3 sections of Bharatiya Nyaya Sanhita. However, 2 of the section, namely 329 within bracket 3 and 117 within bracket 2 are bailable, whereas section 74 is non-bailable. So he submits that in the FIR, no ingredients of any alleged offense regarding outraging the modesty of the informant has been made out. Stop. What else is your submission?
And another submission of the entire matter is civil in nature. She borrowed money, she refused to pay when I demand.
He also submits that the FIR has been lodged for settling this scores with the petitioner as the informant has failed to repay back the loan which she took from the petitioner. Stop. Learned additional public prosecutor submits that perusal of the case diary would be necessary.
74 seems to be appear. So he not may dispose of
Considering the contents of the FIR, custodial detention.
Not necessary. Submits that considering the perusal of the case diary, considering the nature of the allegations leveled in the FIR, custodial detention of the petitioner may not be necessary for fair completion of the investigation. Considering the submissions made by learned counsel for both the sides, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of Dispur PS case number 1270/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Now, if he does so, in the event of his arrest in connection with Dispur PS case number 1270/2024, the above named petitioner shall be allowed to go on bail of his 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. This bail application is accordingly disposed of.
Lordship, I have to chant for the key. Lordship, there is no affair, Lordship.
No affair. Then where is the apprehension?
Lordship, what has happened, Lordship? I am a doctor by profession, and I had a business of medical equipment with one Shamir Ali and Deepak Kalita, so-called complainant. Lordship, after COVID, my business went very bad. Then these people start demanding money, and they threatened me that they will file a case against me. Lordship, at that moment, Lordship, I have been working as a resident doctor at a clinic in Kolkata. Lordship, in the month of June and July 2023, and again August, September 2024, police has come to my house in Guwahati and asking about me. Lordship, so I have a.
We'll call for a report from the
Lordship,
third Mr. P.K.
M. Alam.
What is your name?
M. Alam.
Third Mr. M. Alam, learned counsel for the petitioner. Also heard Mr. P. Thakur. This application under section 482 of BNSS 2023 has been filed by the petitioner apprehending his arrest in connection with a case which, according to petitioner, has been lodged by one Deepak Kalita or Samim Ali against the petitioner in the said police station. However, he has not mentioned any police station case in this affair. In view of above, the officer in charge of Dispur police station is directed to let this court know before the next date as to whether any case has been registered against the petitioner. You are a doctor? Against the petitioner Jyotirmoy Lohkar in Dispur police station. Let this case be listed again on 13th of December. Then an additional public prosecutor is requested to get the report from the concerned police officer in charge of concerned police station.
Motion for review to application. The connection with Bhubagat is plus 124 under section 310 close to BNS. Question SR is please starting.
Atul. এই বুকিং বিলাকৰ মাইক্ৰোফোনটো কাম কৰা নাই। Where is the FIR?
Please starting motion.
1-3. What is the allegation?
Robbery motion.
Huh? Robbery or dacoity? Yes, Mr. Thakur. Dacoity. CD would be required. Not now. We are fixing a short.
The owner of the eldest vehicle at Lordship, the petitioner and the owner of the eldest vehicle are the resident of same locality. Thereby, the police personnel have visited the house of.
We are fixing a short date. Heard Mr. M. Alam, learned counsel for the petitioner. Also heard Mr. P. Borthakur. P. Borthakur, learned additional public prosecutor. Considering the nature of allegations leveled in the affair, perusal of the case diary would be necessary. Hence, call for the case diary. Please release this matter again on 17th of December.
Pre-arrest bail, my lord. Phase 9 annexure 1 is the affair, my lord. Plus the equity, my lord. My
Yes.
name is not in the affair, my lord.
Then why are you apprehending?
My lord, please, my lord. Obviously, informant will know, not know this. My lord, nobody's name is.
CD would be required.
My profession, driver, permanent resident in Guwahati. Now, because of this.
Which police station? We are fixing a short date. Heard Mr. Not now. Heard Mr. A.K. Hussain, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the same. Release this matter on 18th of. Yes, Mr. Mitra.
Intensity bill application I moved. We'll also go to the page 29 FI. 29 is FI. The 11 portion. Uh, 32. With due respect, I'd like to state that Sri Pranjal Prasad, son of so-and-so, listener has sexually exploited my sister, namely Mrs. Miss Punima Borua, since 1/8/2019, during last 5 years. During last 5 years, the aforesaid Pranjal committed rape upon my sister many times, as a result of which she got pregnant. Concealing a mysterious status on 49/2024, Sri Pranjal Prasad put Varmilan on my sister's head on forehead at Dibrugarh to make believe that she is an unmarried person. On 27/7/24, Pranjal Prasad took my sister to Dibrugarh and proceeded did abortion of my sister 2 months pregnancy without consent. Now we have come to know that Sri Pranjal Prasad is a married person and give promise of marriage. He has committed rape and sexual exploitation of my sister by concealing his original status. Hence, I request to kindly register a case against that. So, that FIR lodged on 28/10/24, and the relevant section case was registered under 376, 493, 313 IPC. Now, my lord, there are two aspects. My lord. What is
BNS. Yes. Yes. Yes.
what are the in para 5 I have stated, page 5, page 4, there are 3 allegations. Allegation of sexual exploitation and rape on the sister of informant since 1/8/2019. Allegation of miscarriage abortion of the informant sister on 27/7/24. Concerning his marital status, the accused petitioner put Varmila under informant system 49/24. All this section, only one section, 1/8/2019. Other sections are that is regarding rape. Other section The date of occurrence is 27/20/24. That is, that BNS come into effect from 1st July 24. Now, what a question, legal question is there? Whether the case can be registered under IPC. All the sections they have put in the IPC. Mainly section 313 and 493 should not be read under IPC because this is after 1st July 24. After
Yes, that may be rectified.
that may be rectified, my lord. But it's not a rectification is also that is not a curable defect. There is judgment on this. That rectify is not a curable defect. It cannot be cured
Why?
because the judgment is there.
What judgment? Suppose police has quoted wrong provision of law in the FIR.
Yes.
Investigation is still going on. They can always rectify it.
They can rectify means they have to change the FIR
No, why FIR has to be changed?
because I'm just relying on one judgment, my lord. So let me go through that. The Karnataka High Court judgment, they have put this. But in this case, the FIR was registered on page 26, my lord. Para 26, page 21. Okay. But in this case, the FIR was registered for 124 for the offence committed on or before 36/24. Therefore, offence must register under the IPC. But FIR was registered on or after 124 only in BSL, but not in CRPC. As regard to the contention of counsel for the respondent, that whether mere mentioning the wrong provision in the FIR can be quashed, but it can be rectified by amendment under section 170 BNS instead of 150 CRPC. In my considered opinion, the FIR is basic document for the purpose of settling the law into motion. And it is also a foundation of investing the matter by police officer for offence registered against the accused. Therefore, it cannot be permissible to invest the matter under 170 BNS for the FIR registered under 154 CRPC after commitment of BNS on or after 1724. It cannot be considered a curable defect. Can we consider?
No, this is not a convincing observation. But we may not agree with this judgment.
May not, it's just observation.
And at this stage, we are calling for the case diary.
And
Then
my lord, once again, they are so far merit point is concerned. Yet, they have been under express, they have under sexual relations in 2019. So it is a so far consistent consensual sexual offenses there. There must be a consent from the girl side. Now, my lord,
no, for that we have to peruse the case diary. What is the age of the victim? What is the age of the victim girl?
I think it was 25 years, 22 or 23, something like that.
Yes, Mr. Kaushik.
Page 35. Look to the one with bail application observed that last day.
Yes.
No, that,
Case diary contains, so these are meetings are there. And the one thing is that, my lord, my learned friend is saying that, my lord, the contention sexual relationship was there. And my contention is that, my lord, that consent was taken by falsehood. Because he didn't have.
Now it is a new offense is also there in BNS, which was not there earlier.
And but 313 and other section, those are combination of 373. Right? That can be added.
and my lord, I have annexed one document, my vital document. Now their intention is to, why it is consensual? Because their intention is to blackmail the victim, the boy. Page 36 is the relevant portion, my lord. I've just annexed that WhatsApp. Last and final demand, 3 Biga Tea Garden, register to 3. What you want to say, replacement before morning. This proves that the whole intention of the family of the girl is to put the boy into trouble and so that they can squeeze money from them.
The document doesn't prove anything. Who's and from where, nothing is mentioned here.
Okay, no, case diary would be required. Heard Mr. S. Mitra, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. this application under section 482 of DNSS, 2023 has been filed by the petitioner Sri Pranjal Prasad, apprehending his arrest in connection with Philobari PS case number 31/2024 under section 376/493/313 of the Indian Penal Code. Learned counsel for the petitioner submits that the FIR in this case was lodged on 28/10/2024, and the alleged offense under section 493 and 313 was committed after coming into effect of Bharatiya Nyaya Sanhita 2024. He therefore submits that this case, as regards the said offences, would not have been registered under IPC, but under BNS. Stop. I have considered the submissions. He also submits that the FIR itself shows that the sexual relationship between the petitioner and victim is alleged to have been continuing since 1/8/2019, which would itself show that there was a consensual relationship between the victim and the present petitioner. Stop. He also refers to a screenshot of a WhatsApp chat purported to be between the family members of who sent this WhatsApp?
His brother. Middleman, some middleman.
Between
Who is the person who
It-
the
received by
this is
this-
the
received by the petitioner, which shows that he was being blackmailed by the family members of the victim regarding the incident alleged in the FIR. Stop. On the other hand, learned additional public prosecutor submits that the bail application of the petitioner was rejected by the Court of Learned Sessions Judge Tinsukia after perusal of the case diary and after finding sufficient incriminating materials against the petitioner. Hence, he submits that case diary may be perused. Now, after considering the submissions of learned counsel for both the sides, perusal of the case diary is felt necessary. Hence, call for the case diary. Fixing 1912 for case diary.
1912. Madam, in the meantime, that interim bill may be allowed, madam.
Not now.
Because
We may, you may fix an earlier date, but after,
Philobari.
because your anticipatory bail was once rejected by the Sessions Court
Yes,
after perusal of the case diary. So not without perusing the case diary.
it's for 20, madam.
Okay, 2012.
May appeal, for it application offense of cheating and misappropriation of allegation in page 17.
Cheating and
Cheating and misappropriation.
misappropriation.
Basically, allegation is that I helped the informant in getting her pension because she was a literate person. And her now allegation is that I have used her name in taking loans and all. That what you also will kindly see, page 17. Page 17, you also will kindly see.
Yes,
Where?
yes.
On the last portion also.
On the other hand, he took away my voter ID card, PAN card, Aadhaar card, bank passbook, ATM card, etc., and thereby depriving me of various benefits. It has come to an knowledge that loans were taken in my name from the bank and the repayment was the same was made by using my pension. How I can take that loan? It was in her name and it is, the installment has gone for her pension funds. I cannot, the bank will not give me the money. We give it to her only, check will be there. And I have stated in para 9 that out of that loan, she has considered a household. Because some dispute.
No,
arose,
loan, allegation is that you took the loan
In her
using,
name. I
using
cannot
her.
take her in her name. That particular also, it has come to my knowledge that loans were taken in my name from the bank. And the repayment was the same was made by using my pension funds. Actually, loan was in her name. And then that installment will go from her pension fund. I cannot get the money.
But she,
She is
Is
making
an-
an allegation, but that loan was in her name. Suppose if she gets a loan, I cannot take the money. Bank will not give me the money. It will be given to her only. And they were moreover, Lordship, they have filed one pre-litigation case. And except to your Lordship, you can see prior to this FIR, after the present FIR was filed, without any direction from the court. And I appeared there,
where is pre,
page 22 and except 2. Prior to filing of the FIR, they filed a pre-litigation case. And I appeared there also.
what happened then?
That is pending. That is pending, no direction. That is still pending. It was fixed on 1811. 1811 I appeared. I pray that I'll appear before the IO.
You appeared before the mediation.
I have appeared. On 1811 I appeared because it's pending now.
Yes, Mr. Kaushik.
It was the fireman. Spending. It's not about loan.
That but documents were kept.
The documents মানে কি হয়, সকলো কাম সম্পন্ন হৈ মোৰ পাবলগীয়া সকলোখিনি ধন আদি আদৰ দিয়াৰ লগতে মোৰ মোৰ পেঞ্চন আদিও সময়মতে সোমাই আছে। তাৎপৰ্যপূৰ্ণ বিষয় এইটোৱে যে সকলো কাম কাজ আদি হোৱাৰ পিছত দিল্লীত হোৱা নথিপত্ৰসমূহ মোৰ হাতত চলাই ডিএম যোগেদি সেই কাৰ্যৰ পৰা বঞ্চিত পৰা ভাঙি মোৰ আমাৰ পৰিয়ালটো সঞ্চয়ৰ ফালে ঠেলি দিছে। আনহাতে মোৰ পেন কাৰ্ড, আধাৰ কাৰ্ড, বেংক পাছবুক
That I already read Basically,
of the his pension money that his pension money.
Pension money has also been,
he has kept the documents. The pension she is getting, because from their loan, it has gone to loan account. Therefore, I'll appear before the IO, I'll satisfy that with documents I can satisfy out there. That's why she filed a pre-litigation case. Also importantly, I will appear before the IO. From the bank authorities, they will come to know. The moment the police goes to the bank authority, they will come to know. Because loan was in her name, not in my name. Had it been in my name, then I would have been liable.
what happened on 1811?
1811 is pending as per my instruction from John, is pending. No direction was given to me by the mediation center. And prior to that only they have filed the case. The case was filed on, this FIR was filed on 8/11, prior to my appearance. Earlier, on most probably on 4th, they have filed the pre-litigation case. On 8th, they have filed that.
I think apart from the road, as I stated, that living will be paid for.
That's why I have heard. Coming person, here in the FIR also, she has given coming person.
Let us call the case diary.
I'll appear before the IO and show the document.
Heard Mr. D. Talukdar, Lalit Counsel for the petitioner. Also heard Mr. R. Kaushik, Lalit Additional Public Prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, Shri Dilip Guya, who is apprehending his arrest in connection with PO PS case number 115/2024. We are fixing a short date, no interim now.
Initially, they have filed pre-litigation.
No, that is in your favor, that pre-litigation
Because
is,
without any direct form there, they have already on fourth they have filed there, on eighth they have filed there. Without any direct.
PS case number
Yeah,
115/2024. Under section 316, within bracket 5/318,
Section also will not be attractive because for agent and all.
within bracket 4 of BNS 2023. The gist of accusation in this case is that on 8/11/2024, one, Toramai Bhuya had lodged an FIR before the officer in charge of Tiok police station, inter alia alleging that her husband who worked in PW department died in harness, and after his death, she was unable to complete the procedural formalities for getting the pension. And stop. It is also stated in the FIR. The petitioner, the informant took help of the present petitioner who promised to help the informant in getting the pension. Now, it is also stated in the FIR that the informant had handed over documents like voter ID card, PAN card, Aadhaar card, bank passbook, and ATM card to the petitioner. And now she came to know that petitioner has obtained loan in her name and had not returned back the documents which she gave to him. Stop. It is also alleged that the loans taken in her name by the petitioner is also being repaid by using the pension funds of the first informant. Stop. Learned counsel for the petitioner has submitted that the allegations regarding taking loan in the loan amount in the of the first informant by the petitioner is not true. He submits that bank would not release the amount to a stranger to whom loan is not given. He also submits that prior to lodging of the FIR, the first informant also filed a pre-litigation mediation case before the mediation center, Jorhat. And on 18/11/2024, the petitioner appeared before the mediation center, Jorhat. However, it is submitted that on that day nothing could happen, and his case is the pre-litigation case is still pending before the mediation center, Jorhat. He submits that due to lodging of the FIR, the police is searching him and he is apprehending his arrest. He further, learned counsel for the petitioner further submits that the petitioner is ready to cooperate with the investigating officer and he may be protected. Stop. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instance. Let this case be listed again on 7th of January 2024. In the meanwhile, considering the fact that a pre-litigation mediation case is pending between the parties, the petitioner is directed to appear before the investigating officer of TOPS case number 115/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the TOPS case number 115/2024, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on 7th of January.
Master.
Photo three Mati.
An anticipatory application, my lord. Matrimonial dispute, my lord, is eventually aggravated. So the case is registered under section 61(2), my lord.
What is 61(2)?
Criminal conspiracy, my lord. Then 329(3), that is, my lord, criminal trespass, that is bailable, my lord. Then 117 subsection 2 is voluntarily causing grievous, that is also bailable.
Grievous.
Grievous, but my lord, not the sharp offense. The
Okay.
equivalent of 324.
It is bailable. Okay.
324(4), that is, my lord, mischief. 305 is non-bailable, that is theft in a dwelling. And 109, that is, my lord, attempt to murder.
Attempt to murder.
Now, my lord, petitioner number 1 and 2, they are the father-in-law and mother-in-law of the informant, my lord. Petitioner number 1 is 79 years old and petitioner number 2 is 74 years old. The other petitioners are the married sisters-in-law of the informant. Now, my lord, will kindly come to the FIR. Page 11, my lord.
Yes.
Here it is. It is most respectfully stated that today, that is 1/12/2024, at around 2 p.m. in the afternoon, the accused persons entered my house carrying a machete, stake, iron rod, and other sharp weapons. I was working in my house at that time. The accused persons entered and physically assaulted me and my husband. His husband is the son of the petitioner number 1 and 2. When I tried to save my husband, the accused person number 3. Now, accused person number 3 is not before this honorable court. He, coming from backside, attacked me with an iron rod in my head and caused serious hurt. Accused numbers 4, 5, 6, and 7 together choke my neck and snatch away my 1.5 carat gold chain. The accused person number 1, 2, 3, 4, 5, 6, 7, 8, and 9 together break my house. Accused number 1 and 2 broke my mobile phone. The accused persons together tried to kill me and my husband. We somehow came out of the house. The accused persons together threatened us. If we return home at night, they will kill us. So the daughter-in-law and the son, they are living separately from their parents. They have been at discord for a considerable amount of time. On that day, they lost this FIR. Now, even if this FIR is taken on face value, attempt to murder is not made out. The only allegation is accused number 3 had hit with an iron rod. That we still treat with the bailable offense 1172, but that person is not before this honorable court. As far as the other petitioners are concerned, my lord, on the face of the FIR, my lord, the sections which have been invoked, these do not seem to be attracted in the case, my lord. Matrimonial dispute, my lord, which has aggravated.
No, against others.
Others, my lord,
4, 5, 6, and 7.
they entered the house,
Snatch the gold carat.
snatched the gold carat chain. That is one of the typical allegations which is always there in every matrimonial.
No, but why not to believe?
This
Why to
petition-
disbelieve? There must be some reasons.
the reason that, my lord, this, as you know, it is separate from the FIR, my lord, this is the son. Her husband, the informant's husband, is the son of the petitioner number 1 and 2. This is the daughter-in-law, and the others are the married sisters-in-law. The dispute has been ongoing for a considerable amount of time. They have been living separately. So because of this breakdown of the joint family, my lord, this FIR has been lost. Now this 498 cases, since police do not arrest, now these kind of allegations are level minded.
But it may be true also.
My lord,
Suppose it is true.
my lord will allow us to appear before the IO. My lord will give us statement. My lord, the case diary will reveal whether there is any iota of truth in this allegation.
But the biggest concern of the country is process has already pointed out. Messing of the goal Otherwise, please, protect me with a rod.
It is against only Biplab Karmakar.
He is not. He is already arrested.
What is your submission regarding the incident? Whether
This
it
incident is the allegation is an absolutely false allegation, my lord.
it
and
never
because
happened, no?
Never had, nothing of this sort ever happened, my lord.
Injury?
Injury, no such injury would have been sustained, my lord. My lord will call for the case diary along with the injury report. That would reveal whether any of these allegations are.
Injury is there.
My lord will cancel the bill. If my lord will verify whether.
Okay,
it's-
then we'll reflect it.
My lord will reflect it.
Rod and cause serious harm.
Yes, yes. And that too is attributed only to Biplab Karmakar, my lord, not to us, my lord. Whether allegations against us is.
Yes, Mr. Kaushik. Anything?
But these two are the allegation, many allegations. It is person number 3 coming from that side attack me, and that person number 3 is Biplab Karmakar.
He is not a petitioner.
But FIR is drafted in a manner so that nobody escapes.
Clever drafting, my lord.
At 4-5, accused number 4567, together choke my neck and smash away. 4-5-6-7,
But it may be true also.
4, 5, 6, and
Okay,
7, my lord.
we'll peruse the case diary. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also petitioners, also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 482 of DNSS, 2023 has been filed by the petitioners, namely 1, 2, 3, and 5, 4 and 5, who are apprehending their arrest in connection with Lonka PS case number 376/2024 under section 61 within bracket 2, 329 within bracket 3, 117 within bracket 2, 324 within bracket 4, 305/109 of BNS 2023. Stop. The gist of accusation in this case is that on 1/12/2024, the informant Soma De Karmakar had lodged an FIR naming 8 accused persons therein, including the present petitioners, inter alia, alleging that on 1/12/2024 at about 2 p.m., the FIR named accused persons entered into her house carrying a machete, stick, iron rods, and other weapons. Stop. It is also alleged in the FIR that the accused persons physically assaulted the informant and her husband. And the accused number 3 named in the FIR, namely Biplab Karmakar, within bracket, not a petitioner in this case, is alleged to have attacked the informant with a iron rod on her head, causing serious injuries on her person. Stop. Against other accused persons, there are allegations of snatching away gold chain
Trespass and breaking of law.
and trespass into the house of the petitioner, as well as breaking down, as well as causing mischief by breaking the mobile phone of the informant. Stop. Learned counsel for the petitioner has submitted that allegations leveled in the FIR against the petitioners are false, and nothing of that sort had ever happened. He had submitted that the first informant and her husband, within bracket, who is the son of petitioner number 1 and 2,
Brother of 3, 4, and 5.
and brother of 3, 4, and 5, are living separately from the petitioners after their marriage due to some disputes.
Even demanding partition of the ancestral property, my lord, which was not agreeable to that.
So it is also submitted by learned counsel for the petitioner that a false FIR has been lodged against the petitioners as the first informant and her husband were demanding the partition of the ancestral property of petitioner number 1 and 2, which was not agreed to by them. Stop. He also submits that since the
The informant has also suppressed this fact that she is the daughter-in-law of the sister-in-law of the petitioner in the FIR. That has been cleverly.
that will not be. Yes. Mr. R. Kaushik,
That has not been mentioned here.
learned counsel for the petitioner has submitted that since nowadays police does not arrest the accused persons who are against whom allegations of offense under earlier 498A of APC is alleged. Hence, false accusation has been made against the petitioners in the FIR. Stop. He also submits that the petitioners are ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has submitted that the main allegations which are non-bailable in nature is against FIR name accused person number 3 of attacking the informant with an iron rod and against other petitioners of committing theft of gold chain of the informant. Stop. He also submits that perusal of the case diary would be necessary for consideration of the instant bail application. Call for the case diary. Release this matter again on 7th of January 2024. However, considering the fact that the petitioners are the relatives of the first informant, as well as considering the nature of allegations leveled in the FIR, all the petitioners are hereby directed, all the above named petitioners are hereby directed to appear before the officer in charge of appear before the investigating officer of Lanka PS case number 376/2024 and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1. Let this case be listed again on 7th of January 2000. DB. We are rising for DB matters only. We'll sit again. Item number 13. After rising of DB.
Yes, night, I slept. In the next morning,
No, now
was-
trial is going on. It is,
Right.
it is, how many days you are behind? it?
75, considering the prolonged period of detention.
Whether case diary is there?
Is there? They received PM report. Works in a private company. Two small kids.
Let, let us go through the FIR.
Case number 16. Hey, read, I know.
Yes.
সম্মানপূর্ব বিনীত নিবেদন এই যে যোৱা 10/8/2024 তাৰিখে শনিবাৰে ৰাতি প্ৰায় 10:30 মান বজাত মই মোৰ দ্বিতীয় পুত্ৰ শ্ৰী টিকেন দাসক ফোন কৰো। সেই সময়ত মই মোৰ ডাঙৰ ল'ৰা শ্ৰী ভৱেশ দাসৰ ঘৰত আছিলো। ফোনত মোৰ ল'ৰাই মোক প্ৰথমে ভাত খালি নে নাই বুলি সোধে আৰু মায়ে ভাত খালো বুলি মই ভাত খালো বুলি কওঁ আৰু তই খালি নে বুলি সোধত সি মোক কয় যে মই এতিয়া বটলুৰ দোকানৰ সন্মুখত আছো, ঘৰ পোৱা নাই আৰু ইয়াত মোক আজি মৃত্যুত আছে চৰাইছে। Yeah.
What is your name?
বিনাল দাস
Mrinal Das. Who is this Botolu?
শ্বপকিপাৰ।
Okay. okay. You are-
ইয়াৰ পৰা 2-3জন মান ব্যক্তিও আছে বুলি মোক ফোনত কয় আৰু লগে লগে ফোনটো কাটি যায়। তাৰপিছত মই বাৰে বাৰে ফোন কৰো যদিও তাৰ ফোনটো বন্ধ পাওঁ। তাৰপিছত ঠিক 11 মান বজাত মই পুনৰ ফোন কৰো, তেতিয়া মোক ল'ৰাই ফোনটো উঠাই আৰু কয় যে মই ঘৰ আহি পালো, দে ভাত খালো, তই ভাত খালি নে বুলি সোধোতে তাৰপিছত তাৰ ফোনটো মই শুনা নাপালো। মই হেল্ল' হেল্ল' বুলি কৈ থাকিলো। ৰাতিপুৱা প্ৰায় 5 মান বজাত গাঁৱৰ ফুৰিব অহা লোকে আমাক খবৰ দিয়ে যে আপোনাৰ ল'ৰাক কোনোবাই মাৰি ঘৰৰ সন্মুখত পেলাই থৈছে। লগে লগে ডাঙৰ ল'ৰা আৰু মই যাই দেখো যে মোৰ ল'ৰাটোক কোনোবাই ৰদৰে কোবাই মাৰিছে। তাৰ ডিঙি আৰু বুকুত আঘাতৰ চিন আছে আৰু চিনবোৰ দেখি অনুমান হয় যে এইটো এটা পৰিকল্পিত হত্যাকাণ্ড। মোৰ ল'ৰাজন এজন শান্ত স্বভাৱৰ ল'ৰা, দিন হাজিৰা কৰি আমাৰ পৰিয়ালটো পোহপাল দি আছে। সেয়ে মই উক্ত ঘটনা সম্পৰ্কত উচিত তদন্ত কৰি দোষীক কৰায়ত্ব কৰি উচিত শাস্তি দি আছে।
Now, why you were arrested? Mrinal, why Mrinal was arrested?
The police papers, as I had collected certified copy.
On
I have been arrested after a lapse of 45 days. On 26/9,
on what basis you were arrested?
Merely,
Some basis has to
merely
be
that I had slept. I'm not admitting on the previous night that is the only.
kept with the deceased.
Yes, I have slept there 15 days since.
And the dead body was found on the next day morning.
Next day morning, front of victim house.
So you were last seen.
That is not complete, my lord. There is a huge time gap. And as part of telephonic information in the Azahar,
Now, what is your submission?
submission is
75 days.
75 days, prolonged detention.
Then,
Then I am
but you were last seen with the deceased.
passing the disease along with some other person.
Who else was there?
So in front of Botolu shop, Botolu is the prime witness. And there is a conversation between.
You are Mintu.
Yes, into alias Mrinal Das.
You slept.
You slept. That's the only reason. I'm not admitting. But as per the telephonic conversation that is written in the Azahar,
Who informed the first informant that?
that is not mentioned in the Azahar. গাঁৱৰ ফুৰিব অহা ৰাতিপুৱা লোকেজন মানে জনাইছে বুলি কৈছে। As per the LS Azahar, victim safely is his home, at his dinner also. Who dragged him? That is, I do not know.
No,
Some-
from where we can find out the victim reached his home?
As per the telephonic conversation written in the Azahar, page number 60.
Okay, he was having meal.
Yes, at his own risk.
Okay.
Yeah, so link of circumstances not been completed.
Yes, Mr. Bothakur.
Yes, okay, they received my PM report also received.
What are the materials against the?
Material against the accused person because the entire incident occurred, my lord, in the shop of the, my lord, one Botolu. He is also, my lord, known as Pranab Kumar. His statement is available in the case diary. My lord, he stated that, my lord, on that night, my lord, the present accused petitioner slept the deceased. And that is his statement. And some of the other witnesses also, my lord, stated that on the day of the incident, my lord, on that night, my lord, the present petitioner slept. Some fight occurred between the present petitioner and the deceased person. And regarding other 2, 3 person as mentioned in the FIR regarding those persons, there is no name.
No, apart from slap,
Apart
there
from
is an,
slap,
is there any other thing?
statement of.
No, no, don't give it to me. You go through it. Apart from slap,
other
what
witnesses-
else is there?
No, otherwise, only the shop owner stated that
Now, what is the progress?
Yes.
Beyond slap, what is the progress?
now we could receive, otherwise, investigation.
No, to implicate the petitioner,
Now there is only, the statement. of
only
the-
slap is there,
Some other.
but slap is not sufficient.
Victim of circumstance, not admitting.
Otherwise, only.
Any weapon is recovered because somebody has
As per
assaulted
his-
him with
My lord,
a
as per
rod.
the statement of the present accused, what he stated, my lord. মোৰ ক'ব লগা হৈছে যোৱা ইংৰাজী 10/4/2024 তাৰিখে সন্ধিয়া প্ৰায় 10মান বজাৰ ভিতৰত মই বটলুৰ দোকানত পেঞ্চিল কিনাৰ বাবে যাওঁ। মই গৈ বটলুৰ দোকানত পেঞ্চিল লৈ থকা অৱস্থাত টিকেন দাসে মোক কয় যে টিকেন দাস ইজ দ্য প্ৰেজেন্ট পিটিশনাৰ মানে তই ল'ৰা
Not myself. I am Minal Das, alias Pintu.
Yes, read.
টিকেন দাসে মোক কয় যে তই ল'ৰা ছোৱালী পঢ়াই আছা বহুত ডাঙৰ কাম কৰি আছা বুলি মোক কয়। মই দোকানত যোৱাৰ আগৰ পৰাই টিকেন দাস বটলুৰ দোকানত চিগাৰেট খাই আছিল। দোকানৰ ভিতৰত মোৰ লগত টিকেন দাসৰ তৰ্ক বিতৰ্ক হোৱাত দোকানীয়ে মোৰ লগতে টিকেন দাসক দোকানৰ পৰা বাহিৰত উলিয়াই দিয়ে। আমি দোকানৰ পৰা বাহিৰত ওলাই
What is the name of deceased?
name of the deceased is my lord Mintu Das.
Oh, no.
Again,
Petitioner is Pintu.
Petitioner is
who is deceased?
Tiken Das, my lord, is the
Okay,
Tiken Das is the deceased.
okay. Read thereafter. No, you read the complete. Thereafter, what happened?
মই দোকানত যোৱাৰ আগৰ পৰাই টিকেন দাস দ্য ডিচিজ মেলত বটলুৰ দোকানত চিগাৰেট খাই আছিল। দোকানৰ ভিতৰত মোৰ লগত টিকেন দাসৰ তৰ্ক বিতৰ্ক হোৱাত দোকানীয়ে মোক লগতে টিকেন দাসক দোকানৰ পৰা বাহিৰত উলিয়াই দিয়ে। আমি দোকানৰ পৰা বাহিৰত ওলাই আহি পুনৰ আমাৰ মাজত তৰ্ক বিতৰ্ক হয়। মই টিকেন দাসক এক চৰ মাৰি দিয়াত টিকেন দাস মাটিত বাগৰি পৰে আৰু মই ঘৰত গুচি যাওঁ। So he slapped the deceased and thereafter the deceased fell down. Then he went to his own place.
Thereafter, no, nothing is there.
Yes.
Thereafter, nothing, no other
There
evidence
are other witnesses also stated that on that night in the shop of the.
regarding that altercation.
Statement doesn't.
But that has not resulted in his death.
Regarding that, my lord, how, my lord, on the next day morning, my lord, in front of the how that her dead body recovered.
So no findings during investigation.
Only post.
Now, what is your submission? Do you need his detention further?
Now, my lord, because investigation is still, my lord, going on, and regarding these are the materials at present, my lord, against the present accused. So, my lord, police will, my lord, during, my lord, the investigation, because till this time, my lord, 74 days already completed, and till now, from the materials available on record, it reveals that only on that night, one incident occurred between the deceased and the petitioner, and other witnesses also stated that, my lord.
No. Mr. Thakur, after these things are revealed, what steps the IO has taken? In what direction IO is? Or he has, after recording statement of witnesses, he has done nothing. Then whether the further detention of the present petitioner is required or not? If required, why?
It seems that, my lord, further custodial interrogation of the present petitioner may not be necessary from the available materials on record, my lord.
Okay, heard, Mr. Your name is not there.
Technical. My name is not been.
What technical?
To.
Whose name should be reflected in order? Tell his name. You are acting as public prosecutor somewhere. So is there any bar?
No, but my name has not been, lastly not been reflected in the.
What is your name? Heard Mr. Rituraj Vaishya, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Mrinal Das alias Mintu, who has been detained behind the bars since 26/9/2024 within bracket for last 75 days in connection with Polaspari PS case number 293/2024 under section 103 within bracket 1 of BNS 2023. Learned, the gist of next para, the gist of acquisition in this case is that on 14/8/2024, one who lost the affair?
Mother of the deceased.
What is his name? One Sabitri Das lodged an FIR that on 10/8/2024 at about 10:30 PM, she made a telephonic call to her son Tiken Das within bracket deceased, during which no, before speaking to her deceased son, she spoke to Bhavesh Das. Is it?
The conversation between the mother and the son.
The mother was actually, my lord, on that day, my lord,
Mother and whom? Tiken Das.
of the affair, the Bhupesh Das is one of the son of the, my lord, informant.
No, with whom she spoke.
Tiken Das, my lord, this is. From the
Yes,
context of the
you
affair.
can. During which she came to know that on that day, he had one Mintu Das, within bracket, the present petitioner had slapped him. And he was accompanied by 2/3 other persons. Thereafter, at about 11 PM, the informant again called her son over phone and where is the vernacular affair?
Case number 60.
And she was informed that that her son within bracket Tiken Das has reached home. However, during the conversation, ultimately from other end, no sound was the conversation on the other hand stopped and stopped, full stop. On the It is further alleged in the FIR that on the next day morning at about 5 p.m., some villagers informed the informant that her son has been killed. On this, the informant and her other son rushed to the spot and saw that her son has been killed with by assaulting him with rod repeatedly. Stop. On receipt of the said FIR, Palashpuri PS case number 293/24 was registered. Learned counsel for the petitioner has submitted that the petitioner has been arrested merely on the basis of suspicion, as he had an altercation with the deceased on the day of incidents. However, he submits that apart from the allegation that the petitioner slapped the deceased on the date of incident, there is no other material on record to implicate the present petitioner in the offense alleged in the FIR. Stop. He also submits that petitioner has been detained behind the bars for last 75 days, and considering the period of detention, long period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Palashpuri PS case number 293/2024, which was requisitioned in connection with this case. He submits that the investigating officer has recorded the statement of witnesses and PM report is there, and collected the post-mortem examination report. He also submits that from the materials collected by the investigating officer till date, there is clear indication that the petitioner had an altercation with the deceased on the date of alleged incidents. And hence there is a strong suspicion regarding his involvement with the offense alleged, in the offense alleged. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary of Palashpuri PS case number 293/2024. Stop. Though it appears that there are evidence on record, there are materials on record to suggest that on the day of alleged incident, in the evening, at about 10:30 p.m., the petitioner had slapped the deceased in front of the shop of one Botlu. What is the name of the shopkeeper? Botlu, alias Pranab Kumar. However, apart from that, there is no other material to connect the petitioner to the alleged incidents. Stop. The suspicion, howsoever strong, cannot take place of the evidence. And at this stage of the investigation, there may be a strong suspicion against the petitioner. However, nothing beyond that. Stop. Moreover, in light of the fact that the petitioner has already been detained behind the bars for last 75 days, This court is of considered opinion that if the petitioner cooperates with the investigation, with the investigating officer, his custodial detention may not be necessary for fair completion of investigation in Palashbari PS case number 293/2024. In view of above, the petitioner Mrinal Das alias Mintu is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of learned Chief Judicial Magistrate Kamrup Amin Gao, with following conditions, condition number 1 and 2. With send back the case diary. With above observation, this bail application is disposed of.
Item number, my lord, 14, case ID not received, my lord. IO has paid for a short, they can be on 30.
What is the matter?
Arrest around 1811, my lord.
Let the case diary come.
Yes, my lord.
Heard
Can be on
Mr.
12, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner, also heard Mr. P. Thakur, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on
On
when? 12,
12th Thursday, today is 9th.
12/9.
Deeply August.
Yes.
Regular bail application, so total custody more than 1 month, 32 days. Your Lordship.
How many
FIR
days?
is number 8, Your Lordship,
How many days you are behind the bar?
32 days.
32. What is the offense?
So now, the dead body of the victim recovered, my lord.
103.
But I'm not
There are
connected.
sufficient material against the present accused person. On being related by the statement of the accused, my lord, the presently dead body of the victim got recovered. The petitioner number 2, my lord, there are 2 petitioners, my lord. Petitioner number 2, my lord, there are against petitioner number 2, there are sufficient incriminating materials and
What has happened? Actually,
Lordship.
What
It's
is the-
number 8, Exari, Your Lordship. Here FIR 2 accused person, one is Abdullah Ali and another is Rafiqul Islam. Rafiqul Islam is my husband, Your Lordship. He totally.
Who is the
4
petition-
marriages, Your Lordship. I am the first wife and victim is the third wife. Your Lordship. May I read, Your Lordship?
Who is the petitioner?
Petitioner is on Fatima, not FIR name accused person, who is the wife of
Only Fatima and Harmuz is also.
Fatima and Harmuz. Both are brother and sister.
only to pave the way for Hermuz, petitioner number 1 is made as a petitioner number 1, Hermuz is petitioner number, but against Hermuz, my lord. How he,
Against Harmuz, materials are there.
how
Against Fatima,
against Fatima, my lord, he is the sister of Hermuz Ali and other accused person. Rafiq.
Fatima is also in jail.
Yes, in jail. Actually, Lordship, the accused Rafiqul Islam, FIR name accused, my husband, Your Lordship. He deserted me.
No,
several
you,
years.
if you say my husband, because there are 2 petitioners. Husband of the petitioner number 1.
No,
No,
my
no,
lord,
Both the
he
petitioner
is
are brother
sister,
and
my
sister.
lord. Hermuz
brother.
Ali, brother and sister.
Fatima is
Fatima
sister,
Khatun and
Hormuz Ali.
Who is Rafiqul?
Rafiqul is husband of the victim and husband of the petitioner number 1.
Husband of the petitioner number 1.
1 and also victim. Petitioner
First
number
wife
1
of the
is the
parent.
first wife
Okay.
and victim is the third number 1. He
But
solemnized total 4.
We have 2 petitioners.
2 petitioners.
Okay, now you make your submission. Therefore, you cannot say my. You have to say our.
Or pardon me.
Yes. Make,
Part October, Your Lordship, 24 at 3 p.m. on mobile call. The above name Abdullah Ali, my daughter, namely Miss Romana Khatun, 25, son-in-law, namely Rafiqul Islam, going to village Tokrabanda village from rented room at Shantipur hillside, Guwahati, with cash rupees 4 lakhs only and some gold ornaments by leaving their son as a 5 years. After departure of them, I failed to communicate with them over mobile phone. Till date, found switch off of the mobile phone of my daughter, son-in-law. On the other hand, mobile of Said Abdullah has been switched off, who called them.
Now whether 302 has been added? Okay,
But not FIR name case number 1. 2 is the husband, Yolasha, and Fatima is the first wife. Several years before, at least 10 years, he deserted the petition number 1, Fatima, on Rofikul, and he started to decide at Bharlumuk, and he solemnized the victim, Romela Khatun. Romela Khatun, about 5 years before, he said Romela Khatun is third wife of the FIR name accused Rofikul. Yes. And I have no connection and.
Armuz and
communication with the
Fatima are not
victim.
named accused. Mr. Upadhyay,
Harmuz is the
sorry,
main
Borthakur.
extra number 2. Harmuz, Rafiqul and one my lord.
No, only Abdullah Ali and Rafiqul.
Abdullah Ali, my lord, during investigation, it revealed that my lord, Abdullah Ali, Harmuz and Rafiqul, both my lord conspired and my lord ultimately my lord killed the victim and thereafter my lord thereafter, my lord, on the basis of the present petitioner number 2 was arrested on 16/11/24. Petitioner number, and thereafter, my lord, on the basis of his statement on being leaded by him, the dead body of the victim was recovered at Lotia Tukrabanda village, Pahar, my lord, on 18/11.
Okay, what is your submission?
Abhijit is my husband. He is not connection with us. So Hormuz is brother of Fatima. Fatima is no allegation. I think Hormuz, my friend, something against him.
And your lordship, in fact, in
But-
the forwarding report of the present petition, before recovery of the dead body of the victim, in fact, my lord, accused person has stated how they committed the offense. My lord.
Whether Fatima is also involved?
Regarding Fatima, my lord, there is no such, my lord, I have not found in the case diary.
Okay, then we are allowing Fatima.
The investigation is going on. Your lordship may consider case.
Third, Mr. A.A.R. Karim, learned counsel for the petitioner. This application under section 483 of BNSS, 23 has been filed by the petitioners, namely number 1 Fatima Khatun, number 2 Harmuz Ali, alias Muhammad Harmuz Ali, alias Hormuz Ali. Both are arrested on 16/11.
Yes.
Who are detained behind the bars since 16/11/2024 within bracket for last 32 days in connection with Bharolum PS case number 188/2024. The gist of accusation in this case is that one, Miss Asha Khatun, on 17/10/2024 had lodged an FIR before the officer in charge of Bharolum police station, naming 2 accused therein, namely Abdullah Ali and Rafiqul Islam, stating that the daughter of the first informant, Musammat Romena Khatun, was missing from her rented room at Shantipur Hillside under Bharolum police station. And it is stated in the FIR that the first informant suspects the accused named in the FIR of kidnapping her daughter. Stop. On receipt of the FIR, Bharolum PS case number 188/2024 under section 61 within bracket 2/140 within bracket 3 of BNS was registered. Stop. Learned additional public prosecutor who has produced the case diary of Bharolum PS case number 188/2024 has submitted that in the meanwhile, the dead body of Zaid Romena Khatun has been recovered. And section 103 and what else? 60 also.
140 close for
Initially 61, there 143, and thereafter added section 1031 on 2011-24, my lord. After
103.
recovery of the dead body on 18.
103 within bracket 1 of BNS has been added. Stop. Learned counsel for the petitioner has submitted that the petitioner number 1 and no, the petitioners are not involved in the offense alleged in the FIR. He submits that petitioner number 1 was the first wife
passport.
of the FIR name accused Muhammad Rafiqul Islam,
10
and
years before deserted her.
she was deserted by the said accused 10 years ago. Stop. What else? What any other submission?
Further custody we can. Not necessary.
He submits that considering the period of detention undergone, further custodial detentions of the petitioner may not be necessary. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Borlu Mufti's case number 188/2024 and has vehemently opposed the prayer of grant of bail to the petitioner number 2, Harmuz Ali. Stop. He submits that it is from the information recovered, information obtained from petitioner number 2 that the dead body of the deceased would be recovered. He submits that there are sufficient incriminating materials against Harmuz Ali in the case diary, and investigation is still going on. And release of the accused Harmuz Ali would hamper the investigation. So he also, however, fairly submits that at this stage, there are not much materials against.
I just like to comment as per the statement of the present petitioner number 1, my lord. He stated that, my lord, মোৰ স্বামী হাবিজুল আব্দুল্লাহ আৰু কেইজনমান লোকে বুদ্ধি কৰি লটাৰী খেল পতা বুলি মিছা কথা কৈ ৰমেনা খাতুন গুৱাহাটীৰ পৰা লৈ গাঁৱত আহে আৰু তাইক মাৰি কৰবাত লুকাই ৰখা বুলি মই খবৰ পাওঁ। He in fact petitioner number got the information তেতিয়া মই তেওঁলোকক পলাই থাকিবলৈ বুদ্ধি দিওঁ। So this is the
Not much material against her. Stop. Consider. I have considered the submissions made by learned counsel for both the sides and have perused the materials available in the case diary. On perusal of the case diary, it appears that there are sufficient incriminating materials against the petitioner number 2, Muhammad Harmuz Ali, which do not justify releasing him on bail at this stage of the investigation, as doing so may hamper the investigation at this stage. Stop. Hence, the prayer for bail of Harmuz Ali is rejected. On the other hand, however, on the other hand, at this stage, this court is of considered opinion that there are not much materials, incrementing materials against the petitioner number 1, Fatima Khatun, justifying her further detention in this case if she cooperates with the investigating officer. Stop. In view of above, the petitioner number 1, Fatima Khatun, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions, condition number 1 and 2. With above observation, this bail application is disposed of. Send back the case then.
Thank you. The 439 application.
When will you be completing 1 year, 6 months?
Now it is about 1 year, 3 months.
3 months? Okay. Then you argue with one.
Yes, on the merit I will agree. Basically, your lordship, fine, the FIR at page 80,
Page?
118.
Yes.
The FIR, first thing, your lordship, before that, the petitioner is not named in the
Okay.
was subsequently arrested, shown arrested in this case. After he was arrested in another case, he was shown arrested in this case after about, I think,
Shown arrested on which date?
about shown arrested on 26/9/2023.
He was in custody in connection with which case? Earlier.
Connection B, just North Guwahati PS case number 111/23 under section 21C 20 million.
Since when?
I have, so in that case, my lord, it was much earlier. There is one another case also, my lord, against the present people.
Okay.
Anyway, your
Okay.
lordship,
You,
that is date I cannot find here. But what I would like to point out, his name was not there. Secondly, your lordship, he was arrested after about 10 months from the occurrence. The FIR is on 11 July 20, sorry, not 10 months, about 2 months after the incident. 11 July 2023 is the FIR, and he was arrested on 26/9/2023. About 2.5 months. I did the FIR, just not a very long FIR. With regard, I would like to report that on 10/7/23, based on credible source information received regarding narcotics dealer based in Goregaon and Baihata localities with strike at deal either in Amingaon or Balasbai. Area search operation team was detailed for the purpose. It was informed that the Manipur suppliers who were to deliver the contraband have been selected and visited areas for handing over the contraband to the receivers. Accordingly, the same day at 9 p.m., the direction of the DIGP, STF, some Guwahati team from STF under my leadership, along with other separate police teams and the additional SP so and so, have started a joint operation looking out for peddlers. The STF team headed by me was detailed by Swenson. I accompanied by the STF team along with the investigation kit, digital washing and weighing machine, plastic seal, etc. proceeded for conducting the charge operation in our departmental vehicle bearing so and so. And during the time of our search operation, information was received that deal was shifted to another location and that it took place somewhere in Sonapur. Accordingly, all our police team involved in the search operation proceeded immediately to Sonapur near Toll Plaza, as it was suitable place for us to detect and intercept the vehicle used by the peddlers. And at about 1 a.m. of so, the peddlers were traced traveling in 2 vehicles, one Hyundai Creta and one Honda City. The vehicles of the peddlers were tried to be stopped at Sonapur toll gate. However, the peddler in Creta vehicle bearing registration number hit the toll gates barricade and sped off towards the direction of Guam. One round of firing was aiming at the tired vehicle to prevent it from escaping, but the bullet hit the body of the escaping vehicle. One of our police team gave a chase to evade his fleeing vehicle, but it could not be traced out as it managed to escape or hide somewhere under the cover of darkness. On the other hand, the Honda City vehicle bearing registration number was abruptly intercepted at Sonapur toll gate
by our joint police team and the lone peddler, namely so and so, son of so, who was inside the vehicle, was caught hold of and detained accordingly. During the search of the Honda City vehicle at the spot and in the presence of witnesses, suspected heroin of 147 numbers of packet kept inside as many soap cases wrapped in plastic gunny bag have been recovered from the rear passenger seat of the vehicle. As such, the suspected heroin was weighed by me with the help of digital weighing machine belonging to STFPS in presence of independent witnesses. And the net weight so obtained was 1.873 kg, including the soft cases. The above mentioned recovered items along with the Honda City vehicle were seized as per my seizure memo prepared in presence of independent witnesses. Plastic seal so and so used for the purpose of sealing of vehicle. So under that, the case was registered. Here, your lordship, only thing was that another vehicle who broke the toll gate and went off was only the statement apart from the other person who was spotted.
This heroin was recovered
Name is Mofidul.
Mofidul.
Mofidul Haq.
in which vehicle?
In the Honda City vehicle. Honda City. In the back seat of the Honda City vehicle, this was recovered.
And which one was the other vehicle?
The other vehicle is the Hyundai Creta.
Creta,
The Hyundai Creta vehicle.
Creta could not be intercepted.
No, that was not intercepted because it went away.
It broke the barricade and escaped.
It could not be intercepted. That was the brief facts of the case.
Okay.
Now, what has happened, your lordship? After that, the present petitioner was arrested.
This Creta was not intercepted later on also. It could not be found.
Later, because I was already arrested in another case. And after 2.5 months,
This Creta could not be found.
that was later on, your lordship, they have seized the Creta
Where?
from my wife.
That was the Creta which.
That has been now, I think, as per what my knowledge was.
That Creta was actually seized by the North Guwahati police also, my lord, in that case. And thereafter, the present police station, my lord, re-seized the vehicle from the North Guwahati police.
This is in the name of my wife. And
In North Guwahati PS 11123. Was there any recovery of contraband in that case?
In that case, yes, my lord, there was.
in that case, your lordship, no.
Just I want to know.
From the petitioner, there is no. What
In North Guwahati case. Whether in that Creta something was found.
as per my, your lordship, I have seen.
This Creta belongs to your wife.
Yes, it was ultimately, I think,
Manju Begum.
Manju Begum, and it was, I think, handed over to her after it was given custody to her, I think.
Why you were arrested?
That this person, Mofidul Haq, in fact, took my name, number one. Number two, the police said the case that I am person who is involved in such incidents, therefore I am arrested in this case. These are basically these two grounds.
No, but
Here
How
have
you
page
are
27, Page 20, where they have given the specified how I was involved.
yes.
Page 27, the first, the paragraph.
What is this?
That's
Page
sharp.
27 is FIR.
27 is the shown arrest trial.
Oh, shown error.
That you'll also find there.
Yes, that's
27. It starts from actually page 25, 27, my part is that. That, sir, I would like to report that co-accused, namely the petitioner here,
Khalil.
Khalil Rahman, Khalil Rahman, so and so.
You are Khalilur.
Yes. Who was accompanying the arrested accused person Mohammad Mofidul Haq in another vehicle, Lekar Hyundai Creta bearing registration number so and so. He escaped from Nazira Khat Toll Plaza, Sonapur. The PO of STF PS case number so and so on the intervening night of 10/7/2023 and 11/7/2023 by breaking the toll gate of Nazira Khat Toll Plaza at Sonapur when he saw his partner Mofidul Haq Honda car which was transporting huge quantity of then contraband substance in the car was accosted by police, and since that day the co-accused so-and-so has been absconding to evade arrest in connection with STF case number so-and-so. That sir, the co-accused namely so-and-so is wanted in connection with incident case, was arrested by North Guwahati police on so-and-so in connection with North Guwahati PS case number the 111 along with a huge quantity of brand contraband substance. On 16/9/2023, on completion of his police remand in connection with North Guwahati PS case, he was returned to judicial custody and thus is presently lodged in Guwahati Central Jail. That's why the co-accused so-and-so who was arrested by North Guwahati is also required in connection with the instant case. I pray before your honor seeking his custody in police remand for a period of so-and-so days for the purpose of thorough interrogation in order to unearth their modus operandi and of the nexus with other drug dealers, more particularly with the interstate drug nexus. I think, your lordship, with regard to this case, what is recovered, I'll get this, I'm asking other case. Let me find that. Moreover, sir, I would like to draw the kind attention to the black Hyundai Creta vehicle having registration number so-and-so, which was the accused person so-and-so escaped from PO on the intervening night from being apprehended by police. In this incident case, was also recovered and seized in connection with North Guwahati base case number so-and-so. Hence, as this particular black color Hyundai Creta bearing number is also required in connection with the incident case, I pray your honor to kindly authorize seizing of the vehicle from IO of North Guwahati in interest of proper investigation. So basically, this is the case. Now, your lordship will, I'll just take your lordship to a few with regard to this case. Here, my specific, your lordship, contention was with regards to this, how there in the, your lordship, final report that was submitted, that your lordship will find.
Charge sheet has been laid.
Trial is going on, your lordship. In this case,
How many
Uh,
witnesses are there?
there are 15 witnesses. That's
How many have
considered
been?
witnesses, and 8 witnesses have already been done with, in this case, 8 witnesses. I have annexed those, your lordship. I'll come to them. Now, your lordship, what has happened? In the final report, your lordship, in the final report that they have annexed, that I have annexed, in page 45,
Final report or charge sheet?
that's
That page?
page 45.
Your bail was earlier rejected.
Here, this case, it was rejected, your lordship.
On-
And there are 2 cases given in page 47. Was earlier, arrested earlier, your lordship find in page 47. There are 2 cases named, your lordship here.
Yes.
One is Itanagar PS case number so-and-so, and the second is 11123.
Yes.
Itanagar PS case number so-and-so, bail has been granted. That was long back. Bail has been granted because in this case, your lordship, the recovery was less than commercial quantity. I'll come to that if required, your lordship. And the number of witnesses here, your lordship, has been given as 14, that your lordship will find at page 48. Out of these 14 witnesses, 8 witnesses have already been examined. All these examined witnesses are, your lordship, independent witnesses and seized out. From these witnesses,
Because there was no seizure from you, therefore seizure witness will not implicate you.
not included. And also the witnesses, independent witnesses at the toll plaza as well as the other witnesses. That has taken into consideration all these witnesses. What has come out, your lordship? No direct implication of the petitioner in this case. Other cases I am not arguing. In this case, at least there is nothing against the petitioner that I would like to show. And before that, your lordship, they have also stated there were some monetary transactions of the accused, but there is no monetary transactions between both the accused parties that they have not shown. In the charge sheet also they have shown that there are some monetary transactions in the account, but they have not stated specifically what is the amount of money transacted between both the persons. Yes, there have been monetary transactions by individually by this person and the that person.
Here, your lordship, so therefore, the charges in this case is not 20, your lordship, section, it is only under section 29(1) on the NDPS. That your lordship find at page 52. So it is not direct because he is, section 29(1) of the NDPS Act, your lordship will find against me. There are 2 persons charged. 52, your lordship will see that charges. 2 persons, Mofidul has been given 21C. But in my case, it is 29(1) because there is no direct evidence against
Conspiracy.
conspiracy. Conspiracy can be there. So that they can always find. I would like to point out one thing. Your lordship, that would be other file. Just a moment, your lordship. I got the other file. Here with regard to the other case 111, I'd like to point out. In that case, your lordship, 111, I was arrested on 12/9/2023. The other case, just your lordship, just
When?
case, not got a PS case number
12/9.
12/9/2023. Yes, and in that case, your lordship also, nothing was recovered from the possession of the petition. And in that case, your lordship, charge sheet was filed on 28/12/2023. In that case, there were 9 prosecution witnesses and as per your lordship knowledge, there not a single witness have been examined till date.
The charge sheet, what was the allegation against you in this? How you were
Don't have
abetting or
yes, charge sheet.
how you committed the offense,
Which case? The other one.
present case?
Present case, your lordship, only that.
The allegation is that you were party to a criminal conspiracy.
Yes.
Or-
On the ground there, the Hyundai Creta vehicle ran it. Now, whether I was there in the Honda Creta vehicle or not, that is, they are not saying anything. They think that since I am a person who is in the Honda vehicle and I ran it, this is police person. They said therefore they have arrested me, and on the basis of that, I was also arrested in another case in a NDPS matter, you know. This is basically what they meant to say from here. And the second ground was that Mofidul, who was arrested, must have taken my name. Thirdly, your lordship, there were some transactions, monetary transactions. Now the monetary transactions were not between these 2 persons. They've annexed these monetary transactions. The monetary transactions was, some transactions were for Mofidul, 1 or 2 transactions were for the
Khalilur's monetary transaction was with whom?
It was not stated. It was not stated. Here they have annexed that. They have annexed that in the page 50, statement of account of Khalilur Rahman. There are 2 statements of taken. That is on first, in one is Baihatak Chariali branch and another is Polton Broda branch. And in these 2, your lordship, one is 1/4/21 to 28/9/2023. And one is of 5/1/2022 to 13/1/2023. These are the transactions are there, but they did not say with whom the transactions have been. It could be my money coming to me or.
No, in the charge sheet, they have not explained
No, they have.
why this monetary transaction has been mentioned, what it implicates, what it,
They have not.
they have to show that this is,
There is a lot of money has been transferred to my. And both the accused person, there are. Yes, they say, what they are saying.
it is there.
I am trying to say, there have been a huge amount of transactions in the bank account of the petition.
Intersay in between them.
Let's say they have not indicated anyway.
It is saying that
He says that between both the accused person, but they did not indicate how and where. They say that a huge amount of money was in the account, where transactions were there in the account of Mofidul, and also huge amount of money was in transaction with Kholi. These 2, there are transactions are there. And since they have given that data, since Khalilur Rahman is not doing any specific business or something, therefore this money is drugs. That is what they come to the finding. That is what it has been stated. So that is basically on the knowledge of that.
Now suppose 1.87 kgs of heroin has been recovered. To link this recovery with some monetary transaction has to be with regard to this heroin only. Suppose there is other monetary transaction.
What is the, why they fail to any explain, any provide any?
No, suppose
What is their business relation? What is the relation between both the accused persons? My lord, otherwise, my lord, there are three bank accounts, my lord. Only my lord, senior brother, my lord stated about only two bank transactions. My lord, there are one another, my lord, bank account, my lord, of ICCI Bank. And my lord, there are specific note of the IO also and specific date also, my lord, wherein mentioned that this monetary transaction between both the accused persons.
both the means somebody has given.
The present, from the bank account of Khalilur Rahman to the bank account of my lord, Mufizul, my lord.
It
No,
is,
here it is not there in the chart sheet. Mufizul transferred to the bank account of the Khalilur Rahman.
where it is, from where it can be shown.
Page 50, your lordship, if page 50, this is not shown. There are only one account shown of Mufizul Haq, and that is DW8. Then one account shown of your lordship, your lordship, yes.
No, from examination of these accounts, it can be easily found out that from whose account money has been deposited.
50,000 on 22/5/23, 23,000, my lord. Even some other, my lord, not also there, my lord, from the, that is in the, maybe in the. I'm not saying, anyway, let me complete your lordship. Now, your lordship, on this case, there were, your lordship, page 54. This is the PW1. W1 FSL officer, your lordship. And I'm not going to read because it was found to be positive. Here, because nothing was recovered from me, so I do not have much to say about this. Now, your lordship will kindly go to PW2. PW2, yes, your lordship, here. Now comes this is the Nazira Khat Toll Plaza person who is working there. This is it. I'll just read that. On the night of 11/7/23, I was working at Nazira Khat Toll Plaza, Sonapur. On that day at about 11:45 p.m., I saw police person around the toll plaza. So and so is the seizure list, is my secret. No, now the person did not say that one car has broke the toll plaza and ran away. If he is working there. Now in the cross-examination, also will see there are CC cameras installed in the Nazira Khat Toll Plaza. So now the vehicle passing through the toll plaza are recorded in CC cameras. When I put my signature in exhibit P3, it was not filled up. I put my signature in exhibit P3 on the next day morning, but I cannot recollect the time. Now the question is, he did not say anything, either in oath or in that somebody has broken the plaza, toll plaza and ran away. Then again, PW3 at page 59. This is also the toll grid person, possibilities. On oath. At present, I am a student. On 10/7/23, I was working as employee of Sonapur Toll Plaza. Toll gate. My duty was from 4 p.m. to 12 a.m. On the next day, at around 7 p.m., two police personnel came to our toll plaza and asked me about the occurrence that took place on the previous night. And I replied to the police that I know nothing about the occurrence. If there is something is broken in the toll plaza, they say that I have broken the toll plaza and ran away. Why nothing has been stated here, your lords? The CCTV coverage is not there. There is a CCTV installed in Sonapur toll gate, which movement of flying vehicles are recorded. During night, places beyond 50 meters of toll plaza are not visible. If this person has gone through that toll gate, broke that toll gate and ran away, something should have come in the evidence, your lords. These are all independent evidences. Then your lordship will see at PW4. This is also independent. On 10/7/23, I was working as manager in a hotel, namely Trisul restaurant near the Sonapur toll plaza. On the next day, I heard that drug peddlers were arrested on the previous night along with drugs. Now, I do not know what was recovered from whom and where. I do not remember as to who told me that drug peddlers were arrested on previous night along with the drugs. This is the evidences on which they are basing the whole case, Your Lordship. And there are another three witnesses which I have, I think, it is there in the scan copy that I will read. Your Lordship will see. None of them. I have already read three.
No, these are Caesar witness.
Yes.
They will
They are-
otherwise also
Plus,
be.
they have not mentioned any, the manager was also did not mention anything about it. From the near the toll plaza.
Now, out of 14, 8 have been examined. 6 are remaining.
Yes.
Which are the 6 who are
These
remaining?
are these that your lordship will find in the charge sheet itself. Vikram Bosumatari
Page,
is the end. Is page your lordship 40,
Vikram Basumatari is the,
page 48.
Okay.
Now here your lordship, the list of the witnesses have been given. I'll show them. Vikram Bosumatari have not been examined. He is the inspector, Assam Police. Number PW2 Rajiv Nath, Inspector, Assam Police.
not examined.
Not examined. PW3 Saddam Ansari, Sub Inspector Police, not examined. PW4 Rohit Das, Sub Inspector Police, not examined. Now your lordship, who are examined? Pankaj Singh, Assistant Plaza Manager, examined. Mohammad Sahil Hussain, Toll Collector, Nazira Khat Plaza, examined. Mukul Das, Toll Collector, Nazira Khat Toll Plaza, examined. Manoj Dev, businessman, Trishul Restaurant, which I have read, he is examined. Kekhok Gogoi, business grocery shop, examined. Majnoor Ali, retired employee, examined. Ainul Hussain, plumber, examined. Adil Hussain, contractor, supplier, examined. And Abhijit Gogoi, government service, examined. Even I think Monju Begum has also been examined.
Manju Begum is your wife.
Yes, he's also. He's also. Eight has been. He's also. Or she, yes, he's also examined. I think in the last of the other, your lordship, evidences.
You have shown 10 witnesses, examined witnesses.
No, 8 has been. Right, 8 has been, not 10.
2 you have,
Last PW8 is Manju Begum. Manju Begum, not it. Wife is the mother of the present petitioner. He was a wife.
he was examined. Abhijit Gogoi has been,
The scientific.
Adil Hussain,
Adil Hussain was also examined. Yes.
Ainul Hussain,
Ainul Hussain, PW5.
Majnoor Ali,
Majnoor Ali. Just. Majnoor Ali. Yes, Manju Melo. Oh no, Majnoor Ali, yes, he's PW7.
Pradeep Gogoi,
Gogoi has not been. Sorry, that PW7 is the father of the Merit petitioner. And PW8 is Manju Begum, the wife.
Manoj Dev,
Now your lordship, Kekhop Gogoi has not been examined. Kekhop Gogoi.
Kekhop Gogoi is not the name.
5, 6, 7, 8. 8 have been examined. Six, more, Kekhop Gogoi and I think Abhijit Gogoi have not been. Manoj Dev has been examined. PW4.
Mukul Das,
Pul Das have been examined. PW3.
Sahil Hussain,
Sahil Hussain, PW2.
and Pankaj Singh.
Hussain.
Not examined.
Ah.
Now it is 8. Okay.
So,
Now what you want to say?
other your lordship evidences which from which I am
Assuming that they have not implicated.
not implicated at all. No way there is any implication, your
But
lordship.
there are still 6 other witnesses who may implicate you
That is your lordship.
because trial is going on.
Second, your lordship. That may be a point. But what I am trying to point out is there are no implications from here. Your lordship want to read the others also, I can read. The husband and wife and others will not implicate, obviously that is true, but the rest of the are independent witnesses there. Now the toll plaza, the allegation was that the car has broken the toll plaza and ran it. Now what, the two things that should come, that him, so number one is that that car was there in the toll plaza in the CCTV, it broke the toll plaza gate and ran it. These two either in the CCTV or there should be some evidences which will relate to that by independent witnesses. There are 4 or 5 independent witnesses which were taken at the toll plaza. There are Caesar witnesses fine as well as this. Now Caesar witnesses, if I go into that, the Caesar witnesses, both of them say that their signatures were taken later on or they were taken without writing anything there. They have not seen, they have not known nothing. Punch witness, your lordship knows very well. There have to be very clear with regard to your lordship, the recovery of articles. They have to be very precise.
No,
The
no,
witnesses-
your implication is not regarding possessing.
Yes.
Your implication is in conspiracy.
Conspiracy. So what, now conspiracy, how it comes? It comes that one person was arrested from
And,
the toll plaza,
and you have,
second person ran away from it. Broke the toll plaza, broke the gate and ran away. There was some firing was done, but he ran away in a particular car. There were two things have to be there by the police to show that this person was number one in the car, in the Honda Creta car, whether he was there or not, that has to be identified, number one. Number two, that this Honda car, oh, sorry, Hyundai car, went through the toll plaza, broke the toll plaza and went. These are the allegations, this has to be proved. Till these evidences does not prove. Now two things will prove. If they cannot prove by these evidences, these persons who were there in the toll plaza cannot prove it. Who else will prove? Okay, fine. Now they say that by the CCTV camera, they say that this is the CCTV camera report. This is what is found. This is the car which ran away. This is the person who was inside the car. Then I do not have it. If they do not have that, then what basis, your lordship? They will have another 5, 10 witnesses saying, yes, Hyundai car came, broke the toll plaza, ran away. So many, his person is a peddler. Anybody can say that. He's a peddler, he's involved. We have known him. He is a big peddler. He may not be involved in this case. He may be in another case. But in this case, basically, they have to show these two. This person is involved and this person has broken the toll plaza, ran away. Whatever they have given in their FIR, that has to be proved. To prove that I am the person concerned. Where is that? Now they say that I have 2, 3 bank account. Money was coming to my bank account, going out to the bank account. Fine. The other person also. Now they are saying that there is some money transferred between 80,000 between me and Mofidul. Now they have to show that this 80,000 money is with regard to particular this conspiracy, this drug conspiracy where I am. That has to be there. These are the 3 grounds basically on which I am arguing. My learned friend will be able to show that from the your lordship scan copy. That in the scan copy, obviously there has to be something to show that I am the person who was in the car and I am the person who broke the toll plaza.
On what ground your earlier bail application was rejected?
That was your lordship. I have annexed there.
What ground it was rejected?
I have annexed there. Just a moment. So it is your lordship at page 42. Here it was, my submission was that, except the statement of the co-accused, no other material is available. Your lordship has given that on perusing
There are
of the
other
charge sheet, your lordship, after perusing the charge sheet, page 43. This was prior to your lordship. I think it was in 23, about 8 months, 9 months back. On last paragraph at page 43.
So there was material found in the charge sheet.
Yes, that they have to show which is the material, your lordship. Which implicate the present petitioner in this case, and the case involves contraband of commercial quantity. Nothing specific has been added. I am specifically coming up with that. In the charge sheet, they did not implicate anything with regard to the car, where this car was found on that day, at that particular point of time, at that place, and I am in the car, I have broke the, your lordship. That is not there. If they can show that, obviously, then I don't have it. I'll block, close the file and go. You have to be very specific, your lordship, in a case of NDPS where section 37 comes.
No, but in an earlier bail application, an order is passed
Yes.
by this court, holding that there are materials in the.
Yes.
So your only option is,
What are the?
but your only option is to go on appeal before Supreme Court, not before this.
Normally in a bail application, we normally don't go for an appeal.
No,
The
but
second
if,
thing-
if same ground is assailed, you are coming on the same ground.
There is this, at this stage now, at that time, your lordship, witnesses were not.
But
Now
there are,
come.
there are 6 witnesses remaining.
I understand your lordship is very correct. What I am trying to point out at on 23 in the month of March, the witnesses have not been examined at that time. The witnesses are, 8 witnesses, your lordship, are there before your lordship to verify whether there is any. It has come subsequently after 9-10 months before your lordship, where I have come to say that these witnesses are there. Now, the witnesses have come, the implications are there. Now, your lordship, obviously, at that time, the charge sheet was there. They have stated that he is basically the person who is also there. That was accepted by your lordship. And at that time, I do not have the audacity to bring the witnesses because witnesses were not. Now the witnesses have come. From the witnesses, what derive? What I derive is that even though your lordship on that occasion said that from this charge sheet, your lordship has seen that there might be some, this person may be involved. I will not deny it, but at this stage, on the basis of the additional witnesses, additional, your lordship, documents, additional informations, additional witnesses, statements, lordship can see the whole picture. What exactly is
Where is that law? You said on earlier occasion that you will
No,
show some.
no, at that time, the witnesses were not. Witnesses were not, admittedly, my learned friend. At that time, the witnesses
No,
had
but-
not been. Now
But
have
witnesses
examined.
are still,
What has come out from there?
we cannot go in part by part manner. If you are to depend on witnesses depositions, then all witnesses have to be examined. Because the remaining 6 may implicate you.
No, yes, but now what happens? If 8 witnesses, independent witnesses, does not implicate. Now let us assume another 2-3 implicates. What happens in that case?
Then the court will decide whether to rely on
Those witnesses.
or not. But that cannot be, that decision cannot be taken at this stage.
That is a way of looking into it, but whether a person should be kept in custody on the ground of the standard of witnesses that have been examined till date, whether the person
Yes.
can be kept in custody.
Because of 37,
Because of 37. That's
because
what
of
I-
37, you have,
Judgment of Muhammad Muslim, which we all normally show for long inculcation. In the death judgment itself, the court says that prima facie, if the court is satisfied that from the materials on record, that this does not derive. So in that case also, your lordship, witnesses were not examined, all the way. A few, 2 or 3 have been examined, but the court, even it on long inculcation, but on the basis it has stated.
where is the
The
observation?
judgment, I have a copy of it.
Muhammad Muslim released after 7 years of
I am not on long inculcation.
In this case, very promptly, trial going on. And within a period of 1 year and 3 months, total 8 witnesses were already, prosecution witnesses examined. And this is, your lordship is considering bail application. The trial is not going on. So, while embargo of section 37 is also there, And
Let us see, let us see.
Let me
and your
pass.
lordship is
If
considering a bail application where one person is a habitual.
Lordship
offender, there-
reject my bill. I don't have any problem. But at least go through what I'm trying to say.
Yes, let
You will
us,
have all in time to explain your lordship.
yes, which portion you are relying.
kindly take paragraph 18, 1 8. Paragraph 18. I'll just read three paragraphs, 18, 19, 20. It deals with this 60, 37.
Yes,
Lordship has got paper, right? Is in the 8th page.
yes,
The conditions which courts have to be cognizant of are that there are reasonable grounds for believing that the accused is not guilty of such offense and that he is not likely to commit any offense while on bail. What is meant by not guilty? When all the evidences is not before the court, it can only be this 18, I don't know why. As per the counter affidavit dated so and so filed by the respondent state before this court, prima facie determination. This places the court discretion within a very narrow margin. Even the mandate of the general law on bails, so and so, which classify offenses based on their gravity and instruct that certain serious crimes have to be dealt with differently while considering bail application. The additional condition that the court should be satisfied that the accused, who is in law presumed to be innocent, is not guilty, has to be interpreted reasonably. Further, the classification of offense under the Special Act, NDPS Act, which apply over and above ordinary bail conditions required to be accessed by the courts, required that the court records its satisfaction that the accused might not be guilty of the offense and that upon release, they are not likely to commit the offense. These two conditions have the effect of overshadowing the conditions, other conditions. In case where bail is sought, the court accesses the material on record, such as the nature of offense, likely of the accused, cooperating with investigation, not fleeing from justice, even in serious offenses like murder, kidnapping, rape, etc. On the other hand, the court is in these cases under such special acts have to address fixed principally on two facts: likely guilt of the accused and likelihood of them not committing any offense upon release. This court has generally upheld these conditions on the ground that liberty of such citizens have to be in the cases when accused of offences enacted under special law be balanced against the public interest. Next, a plain and literal interpretation of the conditions under section 37, that is, court should be satisfied that the accused is not guilty and would not commit offense, would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special conditions are enacted under section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record whenever bail application is made that the accused is not guilty. That any other interpretation would result in complete denial of the bail to a person accused of offences such as those enacted under section 37 of the NDPS Act. Now, next, the standard to be considered therefore is one where the court would look into the material in a broad manner and reasonably see whether the accused's guilt may be proved. The judgment of this court have therefore emphasized that satisfaction which courts are expected to record, that is, the accused may not be guilty, is only prima facie based on reasonable reading, which does not call for meticulous examination of materials collected during investigation, as held by so-and-so versus so-and-so. And then, Your Lordship, with regard to the delay part also, the court has stated grant of bail into undue delay in trial cannot be said to be fettered by section so and 436A, which is applicable under the NDPS Act. This is referring to Satyendra Kumar. So what court said is the prima facie determination. I'm trying to point out from the records that these witnesses, these records, what they have stated, what they have produced, whether prima facie or lordship finds that this person can be convicted on the offense, whether he is guilty or he's, that's it. If that is there, the lordship will obviously reject the bill. I cannot say that no, lordship, you have to give the bill. I cannot. If he has done that, he can produce that, yes, under this ground, this person will ultimately be convicted, or from the record, he can be seen that he is guilty of the offense, then fine. Otherwise, your lordship, the balance should come to in my favor on the basis of Article 20, as what court says that if this is not done, then in none of the cases in NDPS, Section 37 will come and nobody will get. That is what the court is. This is what I'm trying to tell. That's all. That's all. Nicola.
Yes, Bothakul. What is there?
My lord, your lordship is considering bail of a person, my lord, where there are already, my lord, listed witnesses is 14. Already, my lord, during a period of 1 year and 3 months, 8 witnesses were already examined. And my lord, one, as per my understanding, one witness could not be found.
Could not be?
He could not be found. There is an order that this witness could not be found, the 9th witnesses. So I'm not sure which one has not been found. I think that Singh was not found. Anyway, your lordship, that let him argue, I'll just point out. And my lord, while your lordship is considering a bail application, my lord, and while considering bail application of a person, my lord, my lord, who is already involved in earlier 2 cases. One is.
Earlier 2 cases are mentioned in the charge sheet.
Search sheet, yes, my lord. The Gitanagar PS case number 21921 under section 22C 29 of the NDPS Act. And another case is, my lord, North Guwahati PS case number, already your lordship has 111/23 under section 21C 29 of the NDPS Act, my lord. And here, my lord, although from the position of the, my lord, your lordship has already, my lord, aware about the facts, my lord. The present accused persons, my lord, against him under section 29, my lord, he is involved along with the other accused persons, my lord. And regarding that aspect, my lord, not only the evidence of these witnesses who deposed before the court, there are other documentary evidence, those bank statements and those bank statements needed.
No, is there any evidence that there was transaction from?
There are 3 bank statements, and from the bank statement, it is very much clear, my lord. I will point out, and my lord, I have also mentioned the dates, my lord, and there is no other business relation between the 2 persons, my lord. Then, my lord, what is their appeal now in the bail petition?
No, is there any transaction between 2 accused? Where?
First transfer on 15/5/23.
From whose account to whose account?
From the account of the, my lord, Hafizul Haq to Khalilur Rahman, the present petitioner.
When?
On 15/5/23, my lord, I have found only because the LCR contains a, my lord, huge volume of, my lord, LCR, and my lord.
15/5/23.
80,000.
80,000 from whose account to whose?
Mozizul Haq to Khalilur Rahman. And on 22/5/23, 23,000. I can point out other transaction also, my lord, but his volume of the.
Okay.
And regarding, my lord, at this stage, regarding the, my lord, 30, my lord, embargo of section 37, your lordship, I would also like to point out some recent decision of the honorable Supreme Court, your lordship, may kindly to. This is, my lord, the state of Meghalaya versus, my lord, Italdu, Tumla, Silo, and another, my lord, your lordship, from paragraph 6. And, my lord, earlier your lordship has, my lord, rejected the bail application of the present petitioner, finding materials on the, my lord, case diary and search sheet, my lord. Your lordship, kindly on paragraph 6, my lord, second, third, 6, the third paragraph. In the decision in Collector of Customs New Delhi versus Ahmadaliba Nodira, the 3 judge bench of this court considered the provisions under section 37(1)(b) as also 37(1)(b)(2) of the NDPS Act, with regard to the expression reasonable grounds used therein. This court held that it means something more than the prima facie grounds, that it contemplates substantial and probable causes for believing that the accused is not guilty of the alleged offense. Furthermore, it was held that the reasonable belief contemplated in the provision would require existence of such facts and circumstances as are sufficient in themselves to justify satisfaction that the accused is not guilty of the alleged offense. As relates the twin conditions under section 37(1)(b)(2) of the NDPS Act, that is, firstly, there are reasonable grounds for believing that the accused is not guilty of such offense, and secondly, this is important, secondly, he is not likely to commit any offense while on bail. It was held therein that they are cumulative and not alternative. Satisfaction of existence of those twin conditions had to be based on the reasonable grounds as referred above. So here in this case, my lord, during pendency of the, my lord, Itanagar police station case, while he is in bail, he is again, my lord, involved in committing, my lord, another offense, my lord. So, my lord, how, my lord, that embargo can be, my lord, not considered by this honorable court, my lord? No, my lord, at this stage, my lord, Supreme Court also, my lord, till now, on the ground of long incarceration, last judgment passed on, my lord, in case of Muhammad Zakirul Islam, at the, my lord, my lord, long into after more than 1 year and 6 months, my lord, granted bail. My lord, here in this case, only 1 year, 3 months. And
Okay, well, anything else?
in this case, my lord, at this stage, there are, my lord,
Mr. Mannan, what is your,
verification of two days.
I have one query also. Regarding the second condition of 37, how will you overcome when you have pending cases against you?
So these are cases, your lordship, I'm an accused, I'm not a convicted.
Yes,
I'm not
but,
convicted, now.
but is that not sufficient to hold that if you are released, you may again get involved in NDPS cases?
I'm not convicted, your lordship, there's nothing proved against me in any of the cases.
No, what is the second condition?
So, no, it's not to be
37.
convicted, but an offense. Now, whether I have committed or not, there has to be finalized here, whether this person will commit this offense. Again, if he is convicted, yes, he has done this offense, again, he is doing this offense, that is fine. When there is no conviction in my, I may be acquitted, your lordship, then what? Lordship, if I am acquitted after 3 years, 4 years, what happens then? So I am just pointing them. That query, he might have submitted fine, that I have already 2 cases. In the first case, that is Itanagar, I think, PS
Then
case.
when the second condition would be applicable?
Itanagar PS case, I was granted bail on 17/8/2021.
Yes.
Long back.
No, then this second
Then
condition,
come 111.
you have 2 pending cases against you.
Now,
The section 37(1)(b)(2) says second that he is not likely to commit any offense while on bail.
now
Where is the guarantee?
that guarantee, your lordship, first and foremost, your lordship. This person, first and foremost, your lordship, he has to be a person who has committed some crime. Now he is actually being in custody with another case where he is not convicted, but another case he
Case is
on
pending.
suspicion. There also, your lordship, the record is revealed. In that case also, nothing was recovered from him.
No,
On
but,
suspicion in one case, second case on suspicion.
but charges are framed against you.
charges are
So prima
charges
facie
being
materials,
being just being framed does not make me and convict. Once the charges is framed, just one thing.
so
I'm an accused.
according to you, when this second condition is applicable, only to those cases where there is a conviction.
A conviction or there has been some proof that this person is involved in a particular crime. This crime, whether NDPS or whatever it is, earlier he has done that. This is the proof. He has done that. He is convicted on that. If a person is never convicted till date, and on suspicions 2-3 cases, let it be 10 cases, your lordship. Let them register 10 cases against me. Just because 10 cases registered against me, I will never get it. What is that? You have to prove one case, at least prove one case in 1 year, 2 year, prove it that this person is a convict in one case, he was doing it. Second time, he's again doing it. Wherefrom he's saying it. Number 1. Number 2, with regard to the cases which he has said, that case, your lordship, has not even till date, nothing has progressed. Why, how can you, that also suspicion? One suspicion, second suspicion. In that case, your lordship, according to what I got from my record, there was nothing recovered from it in that case also. Yes, there was a recovery in the Itanagar PS case. I admit the case which was referred to in the charts, Itanagar PS case number 12, where he got bail on 7/8/2021. In that case, your lordship, the quantity that was recovered from him, which was allegation anyway, that was less than commercial. That was less than commercial. And therefore the bail, I have got the copy of the bail order.
No, what
Just right. Then with regard to the next case, since I was having arrested in one case, do you think that I am also I may be the person concerned in the next case, and then tomorrow again some cases will be filed. I may be accused in that case. Being an accused in many cases, that doesn't give them the right that I have done in each and every case. Now they have to prove one case, yes, you have done it in this.
So
case
your
also,
submission
we
is,
can- fine.
your submission is that this second condition of section 37 is applicable only to cases where your guilt has been proved,
That's my.
no, not otherwise.
And secondly, your lordship, with regard to the other part, money part, that in paragraph 15 of my bail application, page 10. That also explained, it is not a huge amount of money, 80,000 and 20 something thousand, which he says. I have given it in page 10. So para 15, page 10. That the accused petitioner begs to state that the accused, namely so-and-so, entered into an agreement to sell a plot of land to the present accused petitioner, for which there was a money transaction between the accused person, namely so-and-so, and the present petitioner, though through their bank. Further, it is stated that all the monetary transactions between the present petitioner and the accused person, namely so-and-so, was regarding the land, and the present petitioner has no knowledge about the suspected contraband, which are recovered from the accused. Now, these things I have stated that I did not read this anyway. Now my learned friend pointed out, I have to. Latest to hoy no hai to agor ghatna hai itia transaction kena ke they are all already in jail. It was prior to the case. Prior to the case, this was done. And this will come up in the, your lordship, in the trial or whatever happens there. That is what I am trying to point out. Number one. And number two, your lordship, I have already submitted. This is the case. And thirdly, your lordship, prima facie, if your lordship sees from whatever is available on the record, that will show that this person, the person concerned in this case, there is no direct involvement can be shown. Under that circumstances, whether he should remain in custody or it should be granted. So that is basically the whole summing up of the three submissions which I make here.
Heard Mr. Y.S. Mannan, learned counsel for the petitioner. Also heard Mr. P. Borthakur, additional public prosecutor. Let this case be listed for delivery of orders on 18th December. 18 December.
I would just like to point out one.
You have not cited any, apart from this Muhammad Muslim, that
I can cite it.
no, on the point that the evidence which has been adduced during trial, during which bail has been filed, can be taken into consideration. Why? You, on last occasion, you submitted that you have some rulings on that.
Yes, I have brought a few things. Now, I would like to point out.
I don't need few, I need only one.
I'll provide a case regarding, so all offences are under IPC, during pendency of the trial, regarding drafting of, this is also a latest decision. And my lord, I would like to point out one another thing, my lord, regarding the present petitioner, one another WPC. Not, preventive, the wife has filed a case. He was also, your lordship, detained under the preventive detention. There is a case filed by the wife against, for that preventive detention.
The case is pending against you.
That judgment will be delivered tomorrow. That judgment will be delivered tomorrow.
Tomorrow,
I can produce the copy along with the judgment which your lordship has. I will find it. I can give it to the ancestral.
no, that judgment would be relevant. No, let me fix it day after tomorrow
Okay, to submit the judgment.
to submit the
Yes.
judgment. The,
No, let it be, lordship can fix it on Monday. Because I don't know whether I'll get a
Okay.
certified copy or not.
কি লিখিলো?
Let it be on Monday.
No. No, learned counsel for the petitioner submits that. And another case in which the wife of the petitioner has impugned the preventive detention of the petitioner
It number I have.
under what act? This is
PIT NDPS. Under the PIT NDPS.
PIT NDPS Act has been fixed for delivery of judge, that is PIT NDPS Act, that is WPC within bracket criminal 21
21 of
22 has been fixed for delivery of judgment on 10th of December 2024. He submits that he would furnish the copy of judgment after its delivery in this case. To facilitate him to do so, let this case be listed again on Monday. When? Mondays on 16/12.
So I may not get it tomorrow, day after.
On 16/12. If you have something, you can also submit on 16/12.
Not-
Etu staple করে দিই। আরো আছেন? Finish? None has appeared for the petitioner on call. Let this matter be listed in the next week on a date to be fixed by registry.